Bom dia a todos, bem-vindos aí ao segundo dia do nosso Congresso Internacional do Instituto Brasileiro de Direito da Construção. É um prazer aí contar com a presença aí de tantos amigos e colegas ilustres aí. E o primeiro dia foi realmente muito especial, tivemos aí apresentações muito interessantes, com muito ricas aí em discussões atuais, né? Tanto em relação à nova lei de licitações, quanto em relação a temas recorrentes aí para quem milita tanto em arbitragens quanto dispute boards envolvendo a administração pública. E hoje a gente vai tratar de assuntos aí bem práticos, né? Principalmente do ponto de vista técnico, né? Das perícias, quando a gente vai falar um pouco sobre a questão dos pleitos de improdutividade, né? Com aí colegas aí renomados e que realmente manjam muito do assunto, e depois sobre lições aprendidas, né? Relacionadas às questões de atrasos e também custos adicionais em direito relacionados a grandes obras. Então, acho que hoje temos aí tudo para ainda superar, né, as expectativas aí com tantos assuntos interessantes. Mas antes disso, eu gostaria, enfim, de agradecer novamente aos nossos apoiadores e patrocinadores, né? Então, eu gostaria de especialmente agradecer ao Barros Pimentel Advogados, o Campos Melo Advogados, Madeira Valentim Galhardo Advogados, o MAMG Advogados, a Sanlagem Consulting, o Mattos Filho Advogados, o Giamundo Neto Advogados, o Instituto para o Desenvolvimento da Engenharia Aplicada a Controvérsias, Toledo Marchetti Advogados, o Curso Prático de Arbitragem CPA, a Construlegal, o Câncer CBC, o IBAP de São Paulo, o IBRADIM e o SEBAR. E feitos esses agradecimentos, eu gostaria só de anunciar, não sei se todos sabem aqui, mas recentemente a gente teve a eleição da nova diretoria do IBDiC, e para quem não conhece, né, essa nova diretoria, eu gostaria de só mencionar quem são os nomes das pessoas que foram eleitas agora na eleição de julho desse ano. Então, eu fui eleito como presidente do Instituto, o Marcelo Botelho de Mesquita como vice-presidente, o Marcelo Medina, o Thiago Moreira, a Cristina Mastrobono, a Adriana Sarra, e a Solange Gomes e a Beatriz Rosa como diretores. Eu gostaria aí de reforçar, enfim, que essas pessoas são muito importantes aí para o IBDiC, que vem dedicando aí ao longo de todos esses anos aí tempo e dedicação aí para o Instituto, e vai ser muito bom aí contar com todos eles aí nesses próximos 3 anos aí, que a gente tem grandes desafios pela frente. E com isso eu passo a palavra para o Marcelo Botelho de Mesquita. Obrigado, gente. Bom evento para todos.
Excelente, Vitor. Eu acho que nós vamos ter um dia hoje muito interessante. Na data de ontem, para quem nos acompanhou, nós tratamos de questões mais estruturais ligadas à nova lei de licitação e também aos DBs e a visão dos órgãos de controle sobre o DB e sobre a arbitragem, e que isso é altamente importante para quem milita na área. Mas hoje o dia está especial, porque nós vamos tratar de questões que são mais técnicas, e o IBDiC tem se dedicado, nos seus congressos, a também abordar essas questões. São questões bem hands-on. Quem milita na área precisa conhecê-las e, invariavelmente, no seu dia a dia, lida com elas. E, para isso, então, o IBDiC trouxe um time de excelentes, experientes advogados e engenheiros consultores que estão atuando aí na ponta, nas trincheiras e com as arbitragens mais complexas, e realmente é um time muito especial, vocês vão ver. Então, hoje a gente vai ter um primeiro painel lidando com as questões de improdutividade, decodificar esses pleitos, que são sempre muito difíceis de a gente fazer. Para os advogados, sobretudo, precisam entender bastante de planejamento para saber como que os engenheiros estão tratando. E depois nós vamos tratar sobre os riscos de atraso, como mitigar, como tratar desses custos. O primeiro painel, a gente vai ter a moderação do nosso colega Flavio Spaccaquerche, e depois, no segundo painel, a moderação vai ficar a cargo da Adriana Bragueta. Então, sem demora, porque estão todos aí já ansiosos para a gente começar, Flávio, queria passar a palavra para você e daqui para frente você coordena e toca esse primeiro painel para nós. Um abraço para todos e que tenham um excelente dia de palestras.
Muito obrigado, Marcelo. Obrigado, Vitor, pelas introduções. Vou começar aqui em português só para dar um bom dia a todos, agradecer, dizer que para mim é um grande prazer, uma grande honra estar moderando esse painel. Como foi colocado, a discussão prática aqui, ter pessoas especialistas no painel vai ser muito enriquecedor e vai ser uma aprendizagem para mim também. E o tema que a gente vai tratar hoje nesse primeiro painel é justamente sobre os pleitos de improdutividade. Então, eu vou começar aqui fazendo a introdução dos meus colegas aqui panelistas, que eu tenho prazer e honra aqui de estar moderando. Começando aqui em português pela Beatriz Rosa, que é engenheira de produção mecânica, com MBA em tecnologia e gestão de geração, distribuição e cogeração, e especialização em engenharia de defesa. Ela é árbitra, ela é mediadora, e ela é perita de engenharia de tribunais arbitrais e no judiciário. Ela também atua como assistente técnico e como membro de dispute boards. Então, ela atua em casos judiciais, arbitrais, especialmente nos setores de energia, e aí inclui geração, transmissão e distribuição, no setor também de edificações, construção civil, plantas industriais, transportes. Então, obviamente, há uma especialista aqui que vai contribuir com uma grande experiência aí nos pleitos de improdutividade. E ela é sócia de Tarobá Engenharia e Negócios Limitada, que é uma empresa que atua bastante aqui no nosso mercado e nas nossas arbitragens, nas nossas disputas aqui no Brasil. Muito bom dia, Beatriz. Now I'm going to switch to English and like to introduce you all to Meera Wagman, and in respect to our foreigners present here in this panel. Meera Wagman is a managing director at Secretariat. She's based out of New York. She has over 20 years of experience in construction industry, specializing in areas of dispute resolution. So she has specialized in delay and disruption analysis, scheduling, claims, cost analysis, project controls, as well as construction and project management. She has provided services to owners and contractors, so she knows both ways across a wide range of projects, including heavy civil and oil and gas, transportation, airports, petrochemical plants, power and energy, and medical facilities, and vertical construction. She has been appointed as independent expert and testified on matters of delay and disruption on construction disputes in arbitration, litigation, and mediation. And she's a fellow of the Project Management College of Scheduling and is recognized as global elite leader and renowned delay expert by Who is Who Legal. So nice to have you here, Meera Wagman, a pleasure. Looking forward to hearing you. And last but not least, Israel Almodovar. I hope I'm pronouncing that right. Israel is an assistant professor at the University of Puerto Rico at Mayagüez. Hope this is correct as well. With also over 20 years of experience in construction industry. He specializes in providing expert witness and advisory services on domestic and international construction projects in areas of schedule delay, cost overruns, and other project management issues. So he has a vast experience in loss of productivity as well. And he has lectured at various international conferences regarding project administration and construction claim issues. And he's fluent in Spanish, of course, of his mother language. So thank you again for being here. And the idea to all here is we sort of figure out that would be more fun to have questions to go around our virtual table here and to see what these experts in their different backgrounds and experiences have to say about different matters regarding loss of productivity. So I think the first question, and I'll kick off this one with Beatriz Rosa, is how is productivity loss understood in your jurisdiction? So starting with Brazil, since we are, this is a conference in Brazil, how is it understood here, Beatriz?
Bom, primeiro, bom dia a todos, bom dia aos colegas de painel e à audiência. Obrigada pelo convite ao Vitor, ao Marcelo, a toda a diretoria do IBDiC. Eu acho que para a gente começar a nossa conversa, a gente precisa entender o que é improdutividade. E para isso a gente tem que entender dois conceitos. O primeiro conceito é o conceito de produção. A produção é aquilo que se produziu, aquilo que se fabricou. Por exemplo, a gente construiu 10 metros quadrados de um piso. Já a produtividade é o quanto se produziu no tempo. Ou seja, construímos 10 metros quadrados em um dia. A produção, ela não está associada ao tempo, e a produtividade, ela está associada ao tempo. A improdutividade fica daí caracterizada quando aquilo que se construía em um dia passa por alguma razão a ser construído, por exemplo, em 2 dias. Se eu estou levando 2 dias para fazer a mesma coisa que eu posso fazer em um dia, eu estou sendo improdutivo e eu estou gastando mais recursos para o mesmo serviço. Portanto, a improdutividade, ela vai afetar o custo direto. É assim que a gente tem que entender, é assim que a gente vem entendendo a improdutividade. É preciso também a gente diferenciar improdutividade de ociosidade. É muito comum haver essa confusão, porque a improdutividade é aquilo que a gente faz mais devagar do que um padrão que tenha sido verificado. E ociosidade é não fazer nada, é ficar de braços cruzados. Então, acho que, basicamente, a gente precisa ter esses conceitos bem claros para que a gente possa entender as metodologias e como que a gente vai analisar em produtividade. Obrigada.
Thank you, Beatriz. So, how about you, Meera? How do you see productivity loss in? Well, I'm going to ask in New York. So, but please feel free to add any other jurisdiction that you may understand it's valid.
Sure. I can talk a little bit about New York and the US, but really just globally. I mean, just all across the world. I think loss of productivity is really, it is a real impact. So I do think that every jurisdiction does acknowledge and view it as a real impact, but one that is extremely complex and in many cases difficult to define and difficult to quantify. When you think about what it actually is, it's productive time and unproductive time almost occurring simultaneously, you know, and you have to weed through that and figure out a way to try and estimate what that loss is. What is the suffering that is occurring when the suffering is occurring at the same time as productive time? And so just in the definition of itself, it's kind of an oxymoron, right? It's a very big challenge to do it. But I do believe everybody and everywhere, especially more recently, it is recognized as a very tangible impact that gets escalated with the larger and more complex projects that we're seeing all over the world. So all of these projects are getting so complex, and that's bringing even more loss of productivity type of claims and disruption type of claims. And so the world will need to kind of stay catching up to a better way or the best ways to capture that and to quantify that. And I think we're going to get into some of those challenges later today.
Yeah, thank you. Yeah, it's definitely the more complex it is to also understand it and calculate it. We'll get there. How about you, Israel? What can you tell us about loss of productivity in well, I think it's US as well, but in Puerto Rico or globally? Feel free to add.
Well, first of all, thanks for the invitation to be part of this panel. It should be a fun hour and a half to discuss this issue with all of you. My main area of work is in Latin America. While I do some work in the US, I kind of want to focus in Latin America. Beatriz brought her experience in Brazil. Meera provided more of a global view of productivity, but Latin America, in the last 10 years, we've done a lot of productivity related claims in the region. And 10 years ago, the concept wasn't that well known in the region. You had contractors trying to put forward claims for impacts of specific RFIs, specific design revisions, weather issues, but they were leaving on the table that cumulative impact of all of these changes, which is what makes disruption a different type of claim, right? As Meera said, we're not providing when you do a disruption claim or you're not focusing on the specific impact of one issue. It's the cumulative impacts of various issues. So contractors were leaving a lot of that on the table because they didn't realize that there was a concept out there called disruption. I have seen parties argue that when you are submitting a claim for disruption, you have to provide the specific impact of each RFI, of each design revision. Well, that's not how it works. I tried to explain disruption to an arbitration panel 4 or 5 years ago. And after I was done with the explanation, one of the arbitrators said, "Oh, I get it. Disruption is the float in the schedule." Okay, I'm in trouble now. So it's a hard concept, but we're getting there. And year after year, we see that we are getting more calls from contractors saying, I got a problem. I have been disrupted in my project by multiple events. So we need help in quantifying it. We see arbitrators that are asking tougher questions about disruptions. They're learning as well. And they're asking a lot of tougher questions about methodologies. So we see that there's been a development and sophistication in the Latin American market about disruption in the last 10 years. As Meera said, it's probably a combination of more complex projects and also a sophistication in the construction law side in the whole region. So I think this is a good segue for all the detailed discussion we're going to have about the issue.
No, it definitely is. Thank you, Israel. And when you were explaining, I can remember a lot of past experiences about these discussions before panels. So it's definitely a tough one. And so now I'm going to start with you, Meera, and maybe you can kick off with this one. How has been the analysis of these claims, the engineering claims regarding productivity loss in your view, since it's a very difficult one?
Yes, so and I have recently seen more and more design claims and engineering disruption claims. Before, years ago, it was more focused on construction, and essentially the concept is the same between construction and engineering, but engineering has decades and years of cultivating this concept and studying it, and engineering just doesn't have that same kind of historic foundation as the construction aspects do, but essentially it's the same. It's looking at the inputs and the outputs, right? And so in engineering, it's the engineering resources, what goes into the design. I think one of the key things that I see in trying to do a disruption claim in design is how do you actually measure your design progress, right? So that's a very different thing than cubic meters of concrete or tons of steel, very easy units in construction, whereas in engineering, it seems more intangible, right? And it seems very difficult to quantify. But if you really break it down, you're talking about hours expended to create design. And so you have to look at the value of each work package, what the budgeted hours were for achieving that design. And then really what I find the most interesting is trying to come up with a way to determine progress across time of these design elements and the design efforts that are being put out there. And there are many different ways to do it. The more discrete the records of the firm, the more discreetly you can look at each design package down to each drawing potentially. You know, how long is it taking for each cycle to go through? I mean, you can, as in any LOP claim, you can go drill down very detailed, or you have to remain a little bit more 30,000 foot level, and that's driven by what information is available. Again, in the US, and I think that the world is trending this way as well, is whether you're talking about engineering or construction, any loss of productivity claim, it's going to be strongest with project-specific, data-driven analyses, right? So that's the top kind of threshold, the gold standard, and then you can work down from there because those things don't exist all the time, or many times don't exist. So you have to start with what should we do, and then what can we do? And you kind of break down your methodology and figure out how you can do it. But engineering is, it seems newer and different, but to me, it's the same thing, just measuring slightly different elements.
Thank you. Thank you. I have another question, but I will wait. I hold myself. What about you, Beatriz? What can you tell us about the engineering claims? How has these claims been analyzed in Brazil and in your experience? And also, if you could comment about how productivity loss can have impacts, related impacts concerning delays, acceleration, variation as well. Can you please tell us a little bit about this? You're on mute. Está no mudo, Bia.
Ok, sorry. Como a improdutividade é fazer uma atividade mais devagar, ou seja, levar mais tempo, né, para fazer um serviço em relação a um padrão, se esse serviço estiver no caminho crítico da obra, essa improdutividade vai afetar o contrato. Ela vai acarretar maior permanência de recursos indiretos e daí vira uma bola de neve. Se a executora do contrato quiser recuperar o atraso, ela vai ter que tomar medidas de aceleração, como aumentar o efetivo, aumentar turnos, e vai gastar mais recursos para isso. Então, a improdutividade, ela tem relação com o atraso, com as questões de aceleração, com variações. E, como Israel falou, realmente, alguns anos atrás, não era reconhecido isso, não se via essa relação. E no Brasil, hoje, já se tem consciência de que a análise, através da produtividade natural, por exemplo, que é a conhecida Measure-Mile, ela é mais interessante. Então, eu penso que com a evolução dos tempos, né, se tem hoje consciência de que simplesmente nas questões de engenharia, não dá simplesmente para comparar o que foi previsto com o realizado, porque você pode ter erros na previsão, você pode ter tido algum engano na determinação também do seu padrão. Então, eu só complementaria com esta informação. Obrigada.
Obrigado, Beatriz. Thank you. Israel, you again. So what do you think about this specific issue of engineering claims?
So let's think about this. The disruption it's a gray area, and a lot of people have trouble understanding it. And we have trouble understanding it even while you are on the construction site, even though you can see something's getting built, you see a building, you see a process plant, you see something going up and you see everything going on, you just realize that it's not right. It's taking longer, it's taking more man hours. And again, that's hard for a lot of us to understand. Well, now you're applying to something that you can't see, which is the progress in engineering. You can see it, but you're looking at pieces of paper or maybe a CAD drawing in a computer, makes it even harder to understand. But I agree with Meera, though. It's at the end of the day, it's all about inputs and outputs. It's all about hours to get to a finished product, which has a different shape and form, and it may not be as clear to everyone, but at the end of the day, it's an output. So the key again, and this will be a theme throughout this panel, it's all about the documentation. You know, how is that engineering firm documenting their progress in terms of hours, in terms of the output, in terms of the impacts that they're having to their progress in engineering? You know, how are they keeping track of, I've been asked for A, B, or C changes, et cetera, so that if at the end you need to put a claim for this cumulative impact, that you have the right information in order to assess it and quantify it. So it's the same, it just makes it more complicated because it's harder to explain.
Yeah, I think it's when you guys are explaining, of course, as a lawyer, I start thinking about evidence, right? So what kind of evidence? It's timesheet, you know, what is the data of the computer that they, you know, how many hours they were spending on a design or something like that. And I think that goes to my next question. I will start with you, Israel, which is what are the productivity loss analysis methodologies equivalent? So I believe there are many ways to calculate this. So what are they? Is the same for construction and engineering claims? Can you enlighten us a little bit on this?
So within all this world of disruption and, you know, the issues of subjectivity and people understanding the concept, there's some international guides, for instance, I'm going to say the ACEI, that give you a list of the different methodologies that you can use, and different that for delay analysis and other type of analysis, they actually provide an order of preference in which for the different methodologies. And at the top you have the measured mile methodology, right, where you're comparing what actually happened in the project. You're not basing your analysis on what if scenarios, you're not basing it on budgets. It's all about what happened during the periods of impact versus periods of no impact or less impact. But to be able to implement that methodology, you need some really good contemporaneous documents. Without that documentation, your measured mile is going to be skewed, or you may not be able to use it. Now, that is the preferred methodology, and there's a big step down to the other ones, because now when you start going to other methodologies, you're looking at factors, you're looking at information that's extemporaneous or external to the project. So now your comparisons are not about what actually happened, is about what happened versus what should have happened under other conditions, other scenarios, other projects. So sometimes that's all we have, and you do the best you can. But once you start getting into that subjectivity, and the measured mile methodology still has some subjectivity in it, but it's more traceable. And we're going to get back to that word later, but it's more traceable to the project documents. The subjectivity of the other methodologies, it's more open to questioning from the other side.
Thank you. What about you, Meera? What can you tell us about this?
I agree with Israel. It's the measured mile is, again, the kind of top, when I was talking about top down, right? So you can start there, and then you go to kind of earned value, measured mile maybe. But then again, I agree, there's a step down for the other methods because, like I said earlier, project-specific data-driven analyses are the most robust. And because they're based in actual data and actual impacts, that are a little bit more tangible for the tribunal or the trier of fact to grasp and understand. They just are inherently more credible, right? Because you're talking about the actual impacts on your project. Then when you go to comparative studies, so you're going to compare, project comparative study is comparing to a similar project in a similar area. Again, you have to make sure you're explaining everything. I think to me, the key is laying out why you have to choose your methodology. So what were your limitations that you couldn't do the measured mile? Why couldn't you do that? Explaining that, then explaining, okay, why did you then choose a project comparison or an industry factor study? Why did you do that? What were the limitations on your specific project that pushed you to that as your only option? So sometimes I tell clients that the report or the analysis, 80% of it's going to be explaining the factual chronology of what happened, why why we have this claim, and what our methodology is, and why it can't be perfect. And then 20% or even less sometimes is the actual calculation itself. I mean, that's the simplest kind of conclusion part of the analysis. It's the buildup of you first have to identify your facts and prove we actually had disruption. There are these impacts that cause this disruption. Then this is how we've decided to analyze it and why we chose that method. The why is very important if you're going to succeed with one of those lesser methods, especially. Even measured mile, you still have to explain many things. As Israel said, I agree. All LOP methods are estimates, all of them. There's no perfectly precise way to quantify these things, right? It's just better estimates versus less better estimates. So the support that you're giving to your estimate is what counts.
Thank you. But a follow-up question here. Can we say that the choice of methodology, hearing you two guys, depends on the quality of documentation, how strong you are?
For sure.
100%.
So tell us about that, Beatriz.
Então, eu acho que o mais importante, concordo com Israel e a Meera, o mais importante é a gente ter em mente que as metodologias de análise de perda de produtividade, elas não são equivalentes. Cada metodologia tem as suas características, as metodologias para serem escolhidas vai depender da qualidade dos registros que existem. Sem dúvida nenhuma, a top de todas é Measure Mile. Agora, quanto mais genérica for a metodologia escolhida, ou se escolher uma metodologia que ela vai gerar resultados da análise com variações muito grandes, você aumenta a chance de prejudicar uma das partes. Então, é muito importante a gente saber escolher qual é a melhor metodologia a partir da qualidade da documentação que a gente tem. E me preocupa um pouco, Flávio, eu já vivenciei algumas situações que o tribunal arbitral se aventurou a determinar de antemão qual era a metodologia que ele queria que usasse. Isso é um crime, na minha opinião, porque você, para escolher a metodologia, você precisa primeiro conhecer qual é o tipo de informação que você tem, para daí poder determinar qual a melhor metodologia naquele caso. E, sem dúvida nenhuma, como a Meera falou, sempre justificar por que você está escolhendo uma metodologia ou outra.
And how about when the experts disagree on methodologies? How can you suggest a way to go through that? If the parties disagree on the methodology.
Isso é muito comum acontecer, né? Por quê? Porque a tendência das partes é buscar algo que vai lhe dar o melhor resultado. Então, é comum acontecer isso. Mas aí o expert, o perito, ele vai analisar friamente para aquele caso que características que ele tem, quais documentos ele tem disponíveis, e ele vai escolher a metodologia. Pode ser uma terceira, pode não ser nem a metodologia que um apresentou e nem a metodologia que o outro apresentou.
Thank you. That topic comes a lot of questions to my mind, but I wait for the audience to make some questions at the end. I have another question here. Maybe I'll start with you, Beatriz, again. And this is a very subjective question, but which is the mystery of productivity loss claims analysis, if there is any mystery?
Eu acho que tem, sim, um certo mistério, mas é um mistério que a gente, conhecendo o que tem que fazer, fica mais fácil. Não é fácil o que eu vou falar, mas o grande mistério, na minha opinião, é a gente separar o que é improdutividade do que é ociosidade. Infelizmente, esses dois conceitos, eles são muito... as pessoas, de uma maneira geral, misturam os dois. E quando for analisar a improdutividade, é muito difícil também, complicado, separar as causas internas das causas externas. Isso também pode afetar a análise. Para mim, esse é o exercício mais difícil que a gente tem em análise de improdutividade.
How about you, Israel? Do you think there is any mystery around this subject?
I'm not sure if the word mystery is the right one, but to me, the big issue about productivity claims, well, there's many of them, but the key one is that the contractor typically doesn't recognize or notice that there is disruption until it's too late, until it's already happened. So, you know, in other claims, let's say delay, you say, well, I know this is going to happen, or I understand this may happen, so I can see the project will be delayed. Mr. Owner, here's the letter notifying you that this change may impact the completion date of the project. Disruption is different. You know, you're in the middle of the storm of the project, and a few months later, you start looking at your cost reports, and there's a big loss there. And that's at that point that you realize there's something going on, and you start trying to figure out what happened. And all of a sudden you start going through the records and you see, well, you know, the inspector for the owner asked me for a favor here. And then someone else asked me for a little change there, but it was small, it was a little favor. Well, a bunch of little favors all of a sudden have become millions of dollars worth of losses. Again, it's until you have already incurred a big chunk of that loss that you realize that it happened, and now you have to put that claim together to explain not only the change, but the fact that because I was doing that little piece of work in one corner of the project, you know, that took longer because, you know, I only had 2 guys to do it, or I had to move around because I was focusing somewhere else, I had to move to that area to do the work. So to me, that's the big mystery, that you realize if you're going through it right in the middle of the storm, and at that point in time, it's really hard to go back and start looking at documentation, because most likely, and what we see a lot is that a lot of the changes are not documented because there were small little favors that you were doing in the beginning. To me, that's kind of the big mystery about these claims.
That's very interesting. Meera, can you comment on this?
Sure, and just picking up from what Israel left off, yes, it's you don't know what you're in trouble until you're in trouble. Exactly what he's saying, and so for me, it leads to another mystery, which is what you were referencing earlier, the evidence. So project controls. So you have to have very good project controls to have a robust loss of productivity claim. But if you don't know you're going to have a claim, how are you defining your project controls and capturing that information? And maybe mystery, again, I think there's many words to describe what we're talking about, but maybe a better word is pitfall that I come across a lot, is that the project controls, especially on larger projects, different aspects are not talking to each other properly on the contractor side especially. So you may have the schedulers may have a very detailed work breakdown structure, very complex, tracking all the progress, very detailed. But then you go to the cost guys and the labor codes are completely tracked differently. So the tracking of the labor and the tracking of the progress don't align. And now we have lots of great data, but very challenging to use to put together a loss of productivity claim, because those are not aligning, and now you're left with looking at it from a global level, which weakens your claim very, very greatly. So to me, it's always trying to get everybody on board or learning more about, okay, these are the things to think about when you're setting up project controls, so that if and when you have an issue, you have the proper evidence and tools and documents and data to try and put together a claim. It sounds very idealistic, I understand, but I think once a contractor goes through that process, it's a learning, right? It's lessons learned, and then you can implement better and better project controls each time, which is why the industry is moving towards more, a stronger and robust loss of productivity claims across the globe, because everyone is learning as we move forward in the industry. So that's what I think.
Thank you. Oh, that's very interesting, and it's I have two questions on my own, but I'm gonna start with a question from Flavio Galvão. Made you a question, Meera, but I think everybody also can comment. He says that regarding engineering productivity, moreover in current days, as majority of designing are in 3D, where progress measurement is a kind of science by itself, most of the case work package is getting more common to measure it, and therefore could be a good reference for productivity analysis. Do you agree with that? Can you comment on that? Do you think this is something that can be used for this analysis?
So I just want to clarify the beginning. The using. Can you just repeat the first half of that?
Yeah. He's saying that regarding specifically engineering
yes.
claims that we were discussing before. He's saying that today most of the designing are in 3D, and then you have and he mentions, for instance, work package to be more used to measure this kind of, because of the system you're using to make the design, it would be more common to use that to measure the actual productivity analysis. That's his comment, and he's asking you to comment on that, if you agree with that. You believe that because it's a 3D and you have a system already that have a science in itself, it would be easier perhaps to make the calculation?
Yeah, I think it could be easier. I mean, it depends on the details of what the outputs are from that system, what it is, how is it broken down. But absolutely, I mean, the more technologically advanced it's just, again, a form of tracking the progress of engineering. So if you're not just interviewing the design engineers and looking at drawing packages, now you actually have something, as we said earlier, Israel and I said, a little bit more tangible, not so invisible, right? I mean, you can see something, and I think it would help not only because I think it would give more refined information for progress. So you're going to be able to maybe drill down a little bit closer to periodic progress tracking instead of just major points in time, which is one challenge of design claims. It's hard to do interim progress tracking. So I think that would help, but also to explain it to the person who's evaluating the claim. You can, it gives you a little bit of a more robust tool to explain. Here is what we were doing, and this work package was supposed to take this many hours, and it took this many because, look, we had to go in and change this section so many times, or the owner wanted to change this part, and it just becomes a little bit easier to use, and also more discrete. The data is more discrete in these systems. So I absolutely agree that that is the future, hopefully.
Thank you. Thank you.
If I could comment on 3D modeling, not so much from the engineering claim standpoint or from the construction disruption standpoint. 3D models are great in order to explain disruption. Sometimes we're trying to explain how changes in the design, small changes in piping created this big impact on a project. And we've used it, for instance, in an oil refinery. And you show that 3D model to the panel and you say, well, here's the issue. This drawing changed that pipe, that pipe, that pipe, that pipe, that pipe. And when they start looking at it, they see, well, it's not a pipe that's on the outside. It's everything is interconnected, because of that change, this little piece of pipe didn't arrive on time. So we had an open piece of piping right in the middle of everything. We couldn't install the rest. So 3D modeling, it's really helping a lot in explaining a lot of this disruption claims because it's more visual. It allows the tribunal to see something that otherwise you would have to show it with maybe a picture, but most likely in 2D drawings. And that sometimes is not the easiest way for someone to understand it.
Thank you.
Flávio, eu acho que qualquer sistema desses todos que tem por aí, eles ajudam a analisar. Mas a gente tem que lembrar que o que vai, de fato, afetar e vai acarretar uma improdutividade é a execução. No fim das contas, é isso. Lógico que se houver uma modificação de projeto, você consegue usar os sistemas para mostrar aonde que impactou. Mas você tem uma série de outras atividades que vêm da própria execução que o sistema não vai resolver. Existem outras explicações que vão ter que ser dadas e utilizar outras ferramentas.
Thank you. I'd like to go back to one point that you mentioned, Beatriz, in the beginning about the delay, and perhaps ask a question that a lot of arbitrators may have asked or sometimes have a difficult time to understand. What is the difference between loss of productivity and delay? You have a delay, you have an impact, and then you have a penalty for that delay. Why loss of productivity is different? Can you guys comment on that? Because I think this probably comes very often, and I'd like to hear you guys. Perhaps Israel, if you wanna start.
Sure. Thanks, Flavio. And it is the question comes up a lot, and there are two different claims, although they can get intertwined. So a productivity claim is looking for the direct costs, for those additional hours or man hours or equipment that it took to complete specific activities because of issues that are outside of the control of the contractor. So it's looking for direct hours. A delay claim, you're looking for the extended overhead, that time-related component of the project, because activities on the critical path were delayed. So from the quantum side, they are different damages. From the analysis of delay, you can have loss of productivity all over the project in critical and non-critical activities. So for your non-critical activities, you claim for the direct cost of the overrunning hours. For the activities on the critical path, you can claim the direct cost of the man-hour overrun or the equipment overrun, but you could also use that extended duration of the activity to claim your extended overhead, but only for disrupted activities that are on the critical path. So that's a big distinction. You can have loss of productivity all over the project, but the delay cost would only apply to those activities on the critical path that were impacted.
Thank you. Beatriz, you wanna comment on that?
Sim, é muito importante o que o Israel falou, porque muitas vezes o que ocorre nos casos que a gente tem é isso mesmo, o tribunal às vezes fica um pouco confuso, como você falou. Nem sempre atrasos, né, que acontecem por improdutividades em atividades que estão fora do caminho crítico, eles são relevantes, e muitas vezes os peritos ignoram esse atraso, porque o que importa mesmo é a gente verificar quais foram as causas dos atrasos no caminho crítico. E a improdutividade, quando ela acontece no caminho crítico, ela realmente tem um impacto. E é o que Israel falou, existem custos relacionados à improdutividade e existe também a extensão do prazo de entrega. Então, isso é importante. A gente vê acontecer mesmo, em muitos casos, as partes começarem a reclamar de atrasos fora do caminho crítico, mas eles, de fato, não tiveram impacto no resultado global, na entrega global.
Thank you. Yes, it's I faced that challenge a few times. It's not very easy to explain sometimes. Meera, do you wanna comment on that?
And I don't know, I apologize if I'm repeating anything, but one interesting aspect of how delay and loss of productivity relate, and I agree with everything that was said about the difference. It's absolutely critical, non-critical, but they can be, you can get yourself into a circuitous loop almost when you're dealing with claims that involve delay, critical path delay, disruption on the project, then that disruption and delay is requiring acceleration efforts. Now acceleration is actually putting you into more unproductive working. So you have a loss of productivity that may be a cause of delay to the critical path. Then you have acceleration that's actually causing more loss of productivity for different reasons, because now you're having trade stacking and overtime and fatigue, and then you're back around to, okay, but now how do I get to claim that loss of productivity because it was originally the root cause of the acceleration was the first loss of productivity claim? And I have seen this, and you get into a very complicated loop because these concepts and these claim issues, which are all ultimately damages and different types of quantum, but they're all can be so interrelated. And that is a major challenge to unpack and unwind that in a way that a tribunal or a judge can understand and actually make a decision about, right? So you have to kind of carve it up so that there's almost a menu for them to say, okay, if I decide this, then that means this, and help with what does all of this mean in the context of entitlement decisions, which the experts have nothing to do with, right? So, and it all comes down, I mean, I know we're talking a lot about data and this and that, but where nobody's talking about the root cause, which is first you have to establish your entitlement, right? So you have to prove the facts, get your contractual entitlement proven that these are claimable disruptive items, right? So the first step is, do you have claimable items that you can put forward? Then you can get into your, Ferris wheel of fun, we'll call it.
And Flavio, it's interesting because people may laugh at this, but we spend hours and hours with the headache of what's going to be the order in our expert report. Do we talk about disruption first? Do we talk about delay first? Do we talk, because it's all a matter of explaining these complex issues to a tribunal. They're not engineers, they're not contractors. They're just looking at a bunch of data that's getting thrown at them. And even us, the experts, we have a hard time explaining it. And again, it takes time just to put together that outline as to what is the best way to explain it, which is probably 80% of the headaches that we have going through an arbitration. How do we take this very complex issue and in a few pages explain it, and in a presentation that may take half an hour, 45 minutes, explain it to a tribunal?
I hear you, Israel. It's definitely challenging. And then I have another question, which is, and I think you with Latin America and Beatriz, Brazil, what for me it's more challenging before arbitrators sometimes is the fact that it's the evidence, it's the actual loss of the damage to prove that actually is the loss that party actually incurred. How do you guys face that challenge in these calculations?
So I learned a word in Spanish from an attorney in Peru. I don't know if it has a translation in Portuguese. There's a word in English, but it's not. The word in Spanish is trazabilidad. How traceable is your information? And I've seen this attorney, who's also an arbitrator, just take an extra from the other side and go, well, how do I trace this fact in your analysis to a contemporaneous document? Oh, I can't? Well, then your analysis is not worth much to me. On the other hand, I've seen them ask the questions, okay, so in this attachment where you have your calculation, you say go to attachment 3, which takes you to attachment 5, and eventually it goes to a daily report, an RFI, some kind of contemporaneous document, or a cost report, or from the accounting system of the contract. So that to me is the key, is how traceable is your analysis to the accounting system, to the contemporaneous progress records in terms of man hours and production, which should tie to the accounting system. How well are you keeping track of the impacts, RFIs, design revisions, weather conditions, mobilizations and remobilizations, standby time, so you can segregate that from your claim. So that is really the key to any claim, but particularly to disruption claims, because of all the subjectivity around it. The trazabilidad is the key for a tribunal to give it a lot of weight when you're presenting it.
Thank you, Bia.
A rastreabilidade realmente é muito importante, porque você puxa o fio da meada. Se você vai analisando e você não encontra nos cálculos a mesma, uma relação com aquela documentação toda que você está analisando e com os fatos que você verifica, realmente fica difícil de justificar. Então, eu entendo que a rastreabilidade é mesmo uma questão importante para que você consiga, de fato, provar.
Thank you. Meera, is this any different in US?
So, no, I generally agree. I want to offer a slightly different perspective too, because yes, traceability and tying everything back to discrete documents, as we said earlier, is the best approach, right? But many times, and it happens in the US, it happens all over the world in every jurisdiction I've ever worked in, but sometimes that, as we said, it's not possible. It's just not possible. And the catch-22 that you come to is what we call the contractor, has fallen in love with their initial estimate of loss of productivity, which may not be based on traceable documents or a robust, detailed analysis. It was based on a more high-level calculation, or even just saying, well, we lost all this cost. When we look at our cost report, we must be, something's wrong, and let's come up with this factor or comparative project that's not really comparable, and they fall in love with a very big number. And then you have the owner on the other side who is demanding some kind of an artificially precise and perfect analysis, right? So now you're just stuck, and what's left? Either you're trying to negotiate, or you're going to find yourself in front of a trier of fact, and then you really don't know what the outcome can be, because is it going to be something fair and reasonable? Is that tribunal going to demand perfection, or you're kind of left in someone else's hands, and that is where I think negotiation outside of a formal dispute arena is helpful, because when you can't have a robust loss of productivity analysis that is traceable and supported by documents, you're left with these other less desirable methods, but you're also left with an owner who's likely demanding this level of perfection that's unattainable. And so then what happens? Nobody wins, everybody is stuck. You have to come to some sort of agreement. The contractor has to fall out of love with his original number, and the owner has to give in a little and say, I could lose everything if we go forward and dispute. Let's come to the table and let's talk about this. And I see that more and more where you don't have that luxury of traceability.
Thank you. Thank you. Well, again, just hearing you, it just shows how challenging this claim is for lawyers and for experts and for the clients. I have a question / comment here from Sergio. He's commenting, and I quote, independently of the quality of project controls, at the end of the day, the key problem is reaching agreement with the client. In this respect, please comment on the usefulness of contractual guidelines such as dispute resolution boards and clauses setting a time limit for presentation of claims, and if you think this contributes to reaching agreement. Do you guys want to comment on that? Who wants to start?
Eu posso começar a falar um pouco. Eu sou adepta do dispute board, então eu entendo que quanto mais cedo, durante a execução do contrato, se conseguir solucionar o problema, melhor sempre vai ser para a conclusão, para a execução e para a entrega daquela obra, né? Então, eu penso o seguinte, que quando você tem a previsão nas cláusulas, determinando, por exemplo, um tempo a partir do fato que seja apresentada o claim, eu acho que colabora também para a solução, né? Porque o que a gente nota é que esses casos que não tem dispute board e que chegam na arbitragem com uma pilha de pedidos, né? Eles acabam não só não deixando com que o contrato seja terminado, porque o que ocorre nessa situação é que a obra muitas vezes é entregue e você passa lá mais 6, 7, 8 anos discutindo. Então, é muito ruim, sem dúvida nenhuma, tem perdas financeiras para os dois lados, e o dispute board vem resolver isso, né? Ele vai dando as soluções no decorrer do contrato, e muito provavelmente vai chegar ao final com muito pouca questão não resolvida. E, sem dúvida nenhuma, o custo no final vai ser menor.
Thank you. Meera, Israel, you guys want to comment on that?
From a time limit perspective, it's, of course, we all try to agree during the course of the project and settle issues during the course of the project. It's just the best course of action. You don't want to get to the end of a project and have a bunch of claims that you have to figure out at the end, because that's when things don't work out and you end up going to an arbitration. But disruption, we have to be cognizant of the fact that if I do a measured mile analysis, for instance, or a productivity analysis, right in the middle of a project when things are going real bad, the claim's going to be really big. But things could get better along the way. And at the end of the project, when you look back, maybe that projection that you did for disruption is overstated. So disruption is one of those claims that it's hard to project it. You know, in delay, you kind of make assumptions and this, that, and the other, and you can get to a reasonable result during the course of the project. But disruption-wise, it's hard to make a projection that will be somewhat accurate at the end of the project, because conditions can change in a heartbeat. So when we're talking about time limits for claims, on the disruption side, it's a little harder to say that, yeah, you can figure something out along the way, because conditions can change very quickly.
Meera?
Yeah, I agree with projections are very challenging, and that doesn't mean that that you can't make them. You make them all the time based on historic productivity and trying to forecast forward, and sometimes that's fine. I agree. Time barred claims, as it pertains to disruption, you know, I don't know if it seems unfair and unreasonable somewhat, because disruption claims are so complex and so long spanning across a project at times, and involving different elements and disciplines and causes. So the whole idea of this disruption is it's not a discrete cause with some discrete impacts. It's many death by 1,000 cuts, right? And so you're trying to put time on that and limit what the damage really is. I mean, then the poor contractor may just be left with nothing, because he didn't even realize he was in disruption and losing so much money quick enough. It depends on how short those time limitations are. As far as dispute boards, you know, in my experience recently, I see that it works well because it's non-binding, right? And so if the claim is very big, it's gonna maybe have a decision or maybe get resolved, but then one party or the other may refer it to arbitration anyway. And so then you're going through the process several times, and yes, maybe it gives some cash flow relief during the course of the project, which is great and necessary at times, but you're still going to battle it out later, because the losing party in that non-binding decision is not going to be happy with the result. On the smaller side of claims, or if it's a more localized disruption to a specific discipline or due to some specific element of the project, and it's not wide spanning across the whole project, then I think there can be very good success there, because the parties may be more agreeable to accepting that decision. That's just based on things I've seen in the recent years with non-binding dispute board decisions versus later down the road arbitration.
Thank you. And picking up on that, Beatriz, do you think there are, and if there are, what are they? What are the barriers of let's say, a good faith agreement on productivity impacts between the parties, sort of to prevent a dispute?
No Brasil, algumas partes, elas resistem a apresentar os índices de produtividade que foram utilizados nos seus orçamentos, nas suas propostas. Então, para que as partes possam vir mais tarde, de boa fé, lá pelo meio do contrato, analisar se há ou não improdutividade, teria que ter os índices usados no orçamento. Se eu não disse na contratação quais são esses índices de produtividade, como é que eu posso reclamar e cobrar depois? Essa discussão, ela vai haver sempre, né? Eu não vou dizer também que a apresentação dos índices possa ser uma solução, só porque eu apresentei, então você não vai ter questionamento sobre a improdutividade. Também não é verdade, porque eventualmente você pode ter cometido um erro no orçamento, né? Você pode ter usado, por exemplo, premissas que não se adequaram àquele caso, àquela execução daquele contrato, acabou tendo situações e circunstâncias diferentes daquelas que foram previstas. Mas, basicamente, teria que, na minha opinião, haver mais confiança das partes em compartilhar esses índices, para que mais tarde eles tenham uma base para poder chegar à conclusão se houve ou não improdutividade e poder avaliar também a responsabilidade de quem seria.
Thank you. Meera, do you think there are any barriers for that agreement to prevent a dispute?
Yeah, many. I think we've been talking about a lot of them, everything we've talked about, right? So it kind of goes back to, you know, something you touched on earlier, which is when do the experts not agree, right? When do the experts not agree on methodology? And again, it goes to what I said earlier about what the contractor's view is versus the owner's view is, right? And so if you really have just a foundational disagreement on the factual events that cause the disruption and who's responsible for those, I mean, that's the number one hurdle, right? It's just, no, yeah, we may all agree there was a loss of productivity. Great. We agree it was caused by these issues. Agree. But now it's your fault and it's finger pointing, and that it comes down to the parties just cannot agree on who is responsible for those issues, right? And that's what is a real big challenge that I see that really limits those negotiations. The other issue, again, it goes back to the method. If a better method could have been applied and wasn't, and that can be shown, or that's known by the other party, then the party's not going to come to the table and agree, because they're going to say, well, you took the easy way out and used an industry factor or something, when I know you have these records and you could do a real buildup of a claim, and until you do that, I'm not going to talk about it. Those are the two kind of big hitters that I see. It's first, is it an entitled claim? And two, have you presented the best method possible? And many times the answers to those questions are no and no, and then there's no seat at the table.
Thank you. Israel?
So, as we were saying earlier, you know, and Meera touched on this, contractors realize that they're in the middle of a disruption issue in the middle of the project, and they realize we're having tons of losses. And what I see a lot is that they say, well, Mr. Owner, I've lost X million dollars in this project. It's all your fault. You caused disruption, so you owe me the money. Well, the owner comes back and says, what are you talking about? You know, you've had plenty of issues in this project. I see your people walking around, not doing anything. I see, you know, your equipment has been broken down. So why are you claiming all this cost? You know, there's a lot of this that probably all of it, it's related to your own issues. Well, contractors are there building a project and they're trying to get to a deadline, you know, within time, within budget, and safely. They're not claims consultants. They don't have the time and they don't have the expertise to, in the middle of the project, put together a measure mile analysis. They're not built for that, no pun intended. So now you're stuck in between these two very different positions with a very difficult course of action, because one side is thinking, well, I lost X million dollars. The other side saying it's all your fault. How do you get to that in between without doing an analysis that takes time, takes resources, and takes some special expertise? Can you use some industry standards? Can you use some factors to induce into a conversation? Yes, but now you're depending on how willing is that owner to agree with you that some of the issues are owner related and not necessarily contractor related. So it's a very complicated conversation with multiple steps, and at the end of the day, it's all about the willingness of the parties to come to an agreement. The owners agreeing that they had some issues that impacted the contractor understanding that not the whole loss, or that the loss is not solely related to owner issues. And it's a dance. And sometimes people are not willing to dance with each other.
Thank you. And I don't want to lawyer up the discussion, but a question more of your experience. Do you think that, you know, the type of contract that the parties have entered into would somehow change the way these kind of claims are addressed, or it doesn't matter? It's something that you've seen in different types of contracts, and this shouldn't be an issue. Beatriz, you wanna start, perhaps?
Eu acho que não tem nada a ver com o tipo de contrato, honestamente. Os conflitos vão acontecer, é muito mais, eu acho que cuidar da qualidade dos registros que você tem na execução daquele contrato, cuidar do diálogo das partes para tentar solucionar os problemas o quanto antes e não deixar virar uma bola de neve, e realmente independe do tipo do contrato, realmente. Eu acho que a gente tem que ter em mente que a solução dos conflitos o quanto antes, o diálogo e principalmente a qualidade dos registros, para que depois, se você tiver necessidade de uma análise de atraso ou de improdutividade, você tem que cuidar.
Thank you. Meera, do you want to?
Flavio, could you just repeat your question? I lost my audio for a minute, so
No problem. No problem. My question was, I said I don't want to lawyer up the discussion. I just want to, out of your experience, if you believe that these kind of claims would change somehow depending on the type of contract, or the type of contract that the parties have entered into, doesn't matter for, you know, applying for this kind of claims.
So, you know, I think a couple of aspects of that. Of course, certain methods absolutely depend on the type of contract and the type of project it is. So, especially if you're trying to do certain of the other methods like comparative or industry factors, for sure, with comparative, especially, you need to understand, okay, is it a similar type of project? You know, are there certain terms that would change, you know, how the loss would be viewed or be calculated? You know, I think there are some instances, I'm just trying to think on my experience, that certain elements are actually, in New York especially, I've seen just completely excluded. So the contracts are written with very discrete exclusions of certain types of impact costs. Whereas, you know, especially in other parts of North America or anywhere in the world, there's almost no specificity included in those contracts. And so then you do need to understand, you know, what terms are you contending with, because maybe you'd have a loss of productivity claim and you can build up all of your disruption costs, but only, say you have 10 categories and only 5 of them are actually allowable under that contract specifically. I mean, I have a recent case where it listed exactly, this is what you can claim for productivity loss, this is what you cannot claim. And I actually have never seen one that specific, but it really can limit what you're putting together. And in that instance, if you don't have the luxury of good records to discretely categorize your costs into these different buckets, and you're only left with a global, you may be out of luck altogether because of the inability to assign it to the allowable categories versus the non-allowable categories. And that just, I mean, talk about challenges, that really adds on a new layer.
And the creativity of the lawyers. Israel, you want to comment on that?
Yeah, from an analysis perspective, and barring these specific exclusions you may have in some contracts, I don't think that the type of contract changes the fact that you want to have an analysis that's based on the actual conditions of the project. It may change the form of the conclusion. Like if you have a unit price contract, then you're probably not going to be claiming for the cost of discrete hours or the cost of certain amount of hours, but you're going to be looking to change the unit price in the contract. On the other hand, we see these types of claims on every type of contract. I mean, you would even think that a cost reimbursable contract is probably the one that would get you away the most from a disruption claim. But we've seen claims where the owner says, well, you charged me $1 million for this work, but you were completely unproductive. So I'm not going to pay the $1 million. I'm going to pay less than that. And now you're involved in a disruption claim for a contract that originally you would have thought, well, whatever I spend, I'm going to get paid for. So I don't think it's that dependent on the type of contract. Maybe the end result and the form of how you present it is, but the analysis typically will be the same.
Thank you. Yeah, that is interesting because, I mean, we're seeing a lot of different types of contracts, and sometimes there is this misunderstanding about, you know, how this could impact some claims, right? We're running pretty close to the end. So I think I would like to ask you guys for final words, perhaps suggestion, tips, you know, how to be more prepared for this kind of claims. Perhaps Israel, you wanna start with that?
Sure. First, again, thank you for the opportunity of being part of this panel. It's been a good discussion. I hope that everyone that's listening in have learned something. That's the goal, and you know, to make this construction industry move forward and learn more about disruption. It's only going to make us better as an industry. To me, the big thing about disruption, yes, it's a gray area. It's hard to understand. It's hard to explain, but it exists. There's ways of presenting it in a robust way, so that the tribunals can understand what you're saying and understand the real impacts that disruption have on a project. But it all ties back to documentation. And we can talk about disruption, we can talk about delay, we can talk about whatever type of claim we're talking about. It always ties back to documentation. And again, while during the course of a project, your engineers, your superintendents, your foremen, they're focused on getting something built. They're not thinking about, in 4 years, I'm going to be in the middle of a claim and they're going to be asking me for all my records. It's hard for them to get out of that tunnel vision, but we need to teach them that that's really needed for various reasons. I mean, there's other reasons outside of claims, but if things are going bad, that's when you need all that documentation. But the only time to write those documents is when things are going bad. So I can't stress enough that documentation of impacts, hours, quantities, tying everything together to an accounting system, it's the key to present these claims, be it during the course of the project, or eventually have an expert look at those records and put together an expert report to submit your claim.
Thank you. Beatriz?
Bom, muito obrigada pela oportunidade, um prazer enorme de conversar com você, Flávio, com Israel e com a Meera. E eu vou repetir o que Israel falou, porque é extremamente relevante que se lembre que a qualidade da documentação é extremamente importante para a análise de qualquer claim. Então, mesmo que esteja tudo indo lindo, maravilhoso, eu não conheço contrato de construção que não tenha uma discussão qualquer ao final. Então, cuidem bem dos reports, dos controles e das informações que possam ser oferecidas depois para que seja analisado numa solução de disputa. Obrigada a todos.
Thank you, Beatriz. Meera?
Well, just to sound like the broken record, yes, of course, documents. But yes, I think we've really got our points across on documentation. I think another thing that is good, because of the issue of not realizing what's happening until you're already in the problem, there are certain things that metrics and kind of tracking mechanisms and checks and balances that can be established or at the outset of the project and be tracked, just like you're tracking your costs and your schedules, but you're tracking your productivity factors for different types of work. You're tracking those costs so that you're not all of a sudden, where did this millions of dollars come from in my bottom line? And it's a surprise almost. I mean, it's shocking that it is a surprise to some people. So, you can start to think about, okay, what kind of regular controls can we put into place so that we are alerted of this issue as early as possible, and then can kind of jump into action and say, okay, let's make our documentation a little bit more robust. So that's something I think contractors are getting more sophisticated in trying to include that almost as part of a risk registry or some kind of a regular review, just like every other monthly review that it occurs, so that it gives you the benefit of, okay, now we can engage, either ourselves or engage the people that we need, or bring in legal counsel to understand what our entitlements are, what position are we in, should we be accelerating? I mean, there's so many factors that could change the future of that project, save the project really, and save a lot of money and a lot of costly disputes down the road. And so, the earlier the better, for sure. So documents, the earlier the better. And then the last advice is, as much as we talk about the data and doing the analysis, again, going back to the 80% of the report is setting it up for the calculation that you're presenting, the factual chronology of the events is paramount. If you cannot lay out your factual chronology to support and tie in and align with the cost that you're claiming, it will fail. I mean, those have to go together, and the stronger that they can go together, the stronger your claim is, obviously, and the easier it is for anybody to understand. So start with that, and so sometimes you have to start with that instead of, how am I just going to get my millions of dollars, right?
Yeah, thank you very much. Yeah, documents, all this factual chronology. I mean, this is something that we try, I think, at least from a lawyer perspective, we try to tell our clients as soon as possible, even when the contractor is being drafted. But this is a challenge. It's a challenge for you guys, for the experts, for the lawyers, and when it goes to the arbitrators, it's also a challenge as well to understand how these numbers are being put in front of them. So I think the discussion was really great. I really learned a lot, Israel. So I'm pretty sure that everybody here also learned a lot. There's a lot of people thanking you guys. And I also want to thank again for the opportunity of being here, hosting this panel. It was really, really a pleasure, and hope we see each other soon, and that we have cases with a lot of documentation, very organized early on, so that it's easier for us to work and make sure that the parties reach a settlement and in the early stage of when the problem arises. So I think that with a couple of minutes before time, I will again thank you guys. Thank you for Vitor, Marcelo, and IBDiC for the invitation, and hope everybody enjoyed. Thank you.
Thank you so much.
Thank you.
Thank you all.
Obrigado, Flávio. Thanks for everyone. Israel, Meera. Obrigado, Bia. Foi excelente a apresentação. Sempre aprendendo muito com vocês e espero que todos tenham gostado.